intent to kill is formed with one reflection, deliberation, reasoning, or willing, rather than on sudden impulse. Court disagree on the evidence required to show premeditation and deliberation. Some court will defer to a jury finding that the defendant acted with the premeditation and deliberation when the defendant had the opportunity to do so. Other court will require defect proof that the defendant did premeditate and deliberate. Number 2, killing during incommensurate felony. First degree murder include killing committed during the perpetration of certain incommensurate felony. For example, arson, rape, robbery, burglary, kidnapping, and the sexual molestation of a child. That one is the too heavy. Arson is also first degree arson, second degree arson, third degree arson. First degree arson meaning the fire to house. Second degree arson is for business. Third degree arson is for the mountain or any other places without house and business. That's third degree arson. Rape is for junior. For junior is more heavy punishment. Number 3, killing by poison, bomb, lying in wait, and torture. Killing by poison or bombs, or after lying in wait for the victim, are sometimes specifically made first degree murder. Killing by torture also is sometimes made first degree murder. B, second degree murder. Under statutes that degree murder into degrees, killings committed with the malice of a thought that commit with the malice of a thought that are not specifically raised to first degree murder are typically classified as second degree murder. Capital murder. Capital murder meaning for the severe damage and then to This is separate offense from murder and usually require proof of at least one statutory aggravating factor or special circumstances. A conviction subject the defendant to the possibility of a death sentence. Normally, capital murder, meaning punished by death penalty, death sentence. Number C, felony murder. Any murder is mostly the felony murder. Felony murder rule, meaning a killing, even an accidental one, will be murder if it was caused with the intent to commit felony. Also defend felony feel. They can do it. All co-felons are liable if one of them accidentally cause of death, even when a co-felon is killed. Although court many times will find an exception when a co-felon is the victim. Number 2, limitation on felony murder. Several limitations have emerged, perhaps as a result of the increasing discontent with the rule. A, death of another must be forcible. Some courts require that the death have been a forcible consequence of the felony, although the death usually is found forcible. B, felony must be dangerous. A number of statutes limit application of the rule to dangerous felony. Some statutes felony murder be the dangerous meaning. A number of states limit application of the rule of dangerous felonies. Some states require the felony to be inherently dangerous. Others require only that the felony as committed involve the special or significant risk to human life. Number 3, felony must be independent. Some courts require that the felony is independent of the killing. If the predicate felony was the means by which the victim's death was caused, the felony merging number C one more time. Felony must be independent. Some courts require that the felony be independent of the killing. If the predicate felony was the means by which the victim's death was caused, the felony merged into the killing and no felony murder exists. D, one of the felons must directly cause the death. The modern trend holds that the felony murder rule does not apply when a victim is killed by a resisting victory or Persian police officer rather than by the defendant or one of the co-felons. However, the killing may with still be murder under the awareness of a high-risk murder. B. Death must be caused in perpetration of a felony. The killing must be caused during the perpetration. And for attempted perpetration of the felony, however, in some states, a death caused after the technical completion of the felony may still be felony murder. The preferable position application of the felony murder rule to kill accused during the commission of the felony or Number 3, future of felony murder. Several courts have wholly or in part abandoned the felony murder rule. The effect of abandonment may be minimal since many situations will also support murder charged under the depraved mind doctrine. D. Voluntary manslaughter. Next page. Voluntary manslaughter define a killing that would otherwise be murder, but that was committed in response to adequate provocation is voluntary manslaughter. Voluntary manslaughter is even I knew that's dangerous. If past the time somebody can die, that's the voluntary manslaughter. For example, to find a new car. This guy is new girlfriend, the next seat, and then he go to the big bear, and the bottom, my car is good, it's not so dangerous, over 100 miles from the mountain to the bottom, in case slippery the car, and next stage, the girlfriend is dead. That one is the involuntary manslaughter. No, voluntary manslaughter. Anybody, if I don't have any mind, I kill her. But 100 miles to drive. Anybody knew that's the dangerous. In case there is voluntary manslaughter. Number 2, elementary of provocation reducing murder to manslaughter. The common law requires all 4 of the following elements. Number 1, reasonable provocation. Number 2, the defendant was actually provoked. Number 3, absence of adequate cooling period, and number 4, no actual cooling off. Modern statutes also usually require all or the most of these requirements. Reasonable provocation. The provocation must have been reasonable and judged by the objective standard. Generally, it must have been such as might render ordinary person of the average disposition liable to act rashly, without deliberation and from passion rather than judgment. Reasonable person, in deciding whether particular provocation would provoke a reasonable person, ought to differ over the extent to which the reasonable person should be attributed with the defendant's peculiar characteristics. Some do not consider any of the defendant's characteristics, while others consider some characteristic but not any unusual reduced capacity for self-control. Particular situation. Traditional mere words are not adequate provocation. Minority view accept that at least sometimes mere word can be reasonable provocation in some cases. Violent and painful blows, unless the defendant was at first aggravated assault, and witness one spouse commit adultery, will constitute adequate provocation. Some court will consider an illegal arrest to be adequate provocation. A killing caused during a riot in which both particular participants voluntarily entered in reduced to manslaughter. Number 3, mistake concerning provocation. If the defendant was mistaken as to the extent of provocation, the better view would reduce the killing to manslaughter as long as the defendant reasonably believed she was responding to adequate provocation. Number 4, provocation by someone other than victim. If the defendant intended to kill the provocating party but killed someone else by accident, the killing will be manslaughter. But if the defendant intended to kill someone he knew did not provoke him, the killing is not reduced to manslaughter. Number 5, injury to person other than defendant. The subject of the provocation generally must be the defendant or a close relative. Some courts indicate that if the subject is only friend or distant relative, the provocation will not be adequate. B. Actual provocation. The provocation must actually have caused the killing. Example, the provocation must have been such that a reasonable person would lose control and the defendant, in fact, acted due to passion rather than reason of subjective test. Absence of a reasonable cooling period. The majority of courts that homicide is not reduced to manslaughter if sufficient time elapsed between the provocation and the killing to permit the passion of a reasonable person to cool. Objective test. Number 1, rain flaming occurrence. Under the better view, if an intervening event reminds the defendant of the provocation and rain feigns the passion, the cooling period begins to run again. 4. No actual cooling up. The defendant passion must not, in fact, have subsided during the interval meaning subjective test. Model Penal Code had position extreme disturbance. The code would reduce to murder to manslaughter if the killing was committed under the influence of extreme mental or emotional disturbance, for which there is a reasonable explanation of exercise. This is somewhat similar to the adequate provocation standard, but encouraged submission of the case to the jury. 4. Imperfect defense situation as voluntary manslaughter. Some courts reduced a killing to voluntary manslaughter if the evidence tended to establish defense but force short of doing so because the defendant's conduct was unreasonable. Example, he overreached. Yeah, 10-minute break. We'll go to the rest of it. 예, 요즘 수업 중이라고 받았어요. 무슨 일이죠? 화요일 아침에는 수업 중에 예, 그러면은 내가 들어가기를 2시인 줄 알거든요. 예. 그래? 오케이. 예.
这周过了以后要放多久？没有说到里面。要到1个月。
Please enter your password. Then
So many involuntary manslaughter or manslaughter, voluntary manslaughter happen to be. Number one, involuntary manslaughter defined unintended killing. Unintended killing is voluntary manslaughter if, number one, it is the result of criminal negligence or it is caused during the commission of an unlawful act not amounting to a felony, or that for some other reason is insufficient to trigger the felony murder rule. Number two, killing by criminal negligence. Unintentional killing caused by the commission of any act in a criminally negligence manner is involuntary manslaughter. A. More than civil negligence requires a great degree. Unreasonableness is required for criminal negligence than would otherwise surface for imposition of civil liability. Also, it may be necessary that the defendant actually have been aware of the high and unreasonable risk of death, although this is unclear. 3. Killing by commission of unlawful act. Misdemeanor manslaughter. Misdemeanor manslaughter. Unintentionally killing caused during the commission of an unlawful act. Involuntary manslaughter, unless the unlawful act supports application of the felony murder rule. The act must be unlawful, but need not be criminal. Example, killing caused during a defendant attempted suicide. Next page, limitation. Some states hold that the unlawful act must be null in se. Null in se meaning inherently wrong. Others require that the unlawful act in perpetrated in a criminal negligence manner, and a number of courts require that the death be caused by the unlawful aspect in the defendant conduct. F. Modern statutory distinctions. A. Modern penal code scheme. Modern statutes tend to know land fine, homicide. penal code scheme. Modern statute tend to redefine homicide offense by granting them according to the different stage of mind defined by the modern penal code. Modern penal code meaning in America doesn't have any rule of the criminal, just no law. In case, every case that's different, and all the law school professor make the all different cases, and then to make a sample law. Sample law is they made them. For example, same action in New York, 10 years sentence. In California, 50-year sentence. That's unreasonable. That's meaning for the all together sample for the criminal tension. That is the modern penal code. Modern penal code meaning normally judge count for the caused by modern penal code. Modern penal code scheme, modern statute tend to define homicide offense by grading them according to the different state to mind defined by the modern penal code. The modern penal code defines murder as a killing commit purposely, knowingly, reckless, under circumstances manifesting extreme indifference to the value of the human life. Manslaughter, the code established as a single manslaughter. I'm sorry. Okay. 받았어. 그래. 고맙다. 오케이. Manslaughter. The code establishes a single manslaughter offense which is killing commit recklessly or under the influence of extreme mental or emotional disturbance for which there is a reasonable explanation or excuse. Negligent homicide. The code creates a new homicide offense of negligent homicide. Example, a killing commit negligently. 2. Homicide caused during operation of a motor vehicle. Other modern statutes often contains a separate offense for death caused in the negligent operation of a motor vehicle or by operating a vehicle in an unlawful manner. G. General problems relating to homicide liability. Possession. All homicide crimes require that the conduct of the defendant be proved to have caused the death of the victim. Consequently, problem of causation often arise in homicide causes. 2. Victim must be a living human being. Killing of fetus is a not living human being until fully brought forth from the mother and having an independent circulation. Some states have broaden their homicide statute to include the offense contrary to common law. What does death occur? When does death occur? Under the traditional rule, death does not occur until heartbeat and respiration stop. However, some courts now hold that death occurs when the brain ceases to function. Some court is a heartbeat stop. Death is death. Some court is brain ceases to function is the death. That's the difference. Number 4. Death must occur with a year and a day. Death must occur with a year and a day from time to cause of death was administered. However, some courts have abandoned this time limitation, while others have modified the time and effect on a criminal case, meaning somebody shoot a gun or happen to the motor vehicle. In case he's not dead, just he's in hospital. If he's dead, that's murder. Not dead, that's not a murder. But waiting for 1 year. 1 year, within 1 year, is that murder. After 1 year, is that's not murder. That's the date is limitation, 1 year, 1 day. 1 year, within 1 year, 1 day, within his death, that's murder. Over 1 year, 1 day is over, that's not murder. That's the important also. Number 5, aiding or causing suicide. At common law, suicide is murder. Suicide meaning for the death by himself. Suicide is murder. The modern view holds that suicide is not an offense. Thus, the aider cannot be guilty as a party. Some statutes, however, make aiding suicide a separate offense. A. Distinguish actively killing another. Generally, one who actively takes the life of another, even if at the other person's specified request, is guilty of murder. Assert other crime against a person. Assault and battery. Assault and battery meaning for the hit and assault and battery. Battery meaning battery is the unlawful application of a force to the person of another. Actus rules. The mere application of a force is sufficient. Under traditional law, no injury or marks on the victim are required. Modern statutes, however, often require either some injury or that the touching application of a force be offensive. Under either approach, the application of force may be indirect. Example, administering position. B. Manslaughter. The application of force need not be intentional. Negligence is usually sufficient. Some codes do not even require negligence where the defendant was engaged in unlawful behavior. C. Effective of consent. There is no battery if the victim effectively consented. D. Punishment. At common law, battery is misdemeanor. As in today's classification of simple battery, however, certain aggravated battery are felony. Aggravated felony, we say mayhem, M-A-Y-H-A-M, mayhem. That's the aggravated battery. Number 2, assault. Two different activities may constitute a criminal assault, but not all states punish other types. 2A. Attempted battery is assault. Unattempted battery is most often an assault. Manslaughter. Generally, the defendant must have intended the application of force to the victim. An intent to frighten is not sufficient for this type of assault. Access rules. The defendant must have progressed sufficiently toward completing the battery. Some statutes require that the defendant have had the present ability to succeed. Conditional assault. Representation by the defendant that she will not commit a battery if the victim completes with the certain demand do not preclude assault conviction. Next page. Intentional placing in fear as reserve, as assault. The second type of assault, recognized in a probable majority of the state, is intentionally placing another in fear of immediately bodily harm. This kind of assault requires that the defendant intended to cause apprehension of harm. The victim must in fact be apprehensive. Example, aware of assault that the defendant conduct must be sufficient to create reasonable apprehension. Mere words are not enough. Model Penal Code. The Model Penal Code definition differs in that the victim need not have actual fear, and the attempt must be put the victim is fear of serious bodily harm. Punishment. Assault was a misdemeanor at common law, and the simple assault remains so but today. Modern statute, however, make certain aggravated assault felony. Mayhem is the mayhem of felony consists of malicious depriving another of the use of one of her members' disablement or injuring the victim so as to permanently change her appearance, meaning disfigurement broken or something. Number one, actus reus. The defendant must have caused the victim bodily injury that permanently disfigured or disabled her. Number two, mens rea. Generally, the defendant must have intended to injure the victim. 3. Punishment. Mayhem is a felony common law, punishable by mutilation. Although the penalty is less dramatic today, mayhem ordinarily remains a felony under modern statute. Punishment. Mayhem is a felony of common law, punishable by mutilation. Although the penalty is less dramatic today, mayhem ordinarily remains a felony under modern statute. C. Rape and relative offense. Rape is unlawful sexual intercourse with a female without her consent. Modern statutes often designate the crime as a sexual assault and classify it as a crime against the person. Number one, forcible or common law rape. The defendant must have completed an actual sexual intercourse with a woman other than his wife and against her will. The slightest penetration of the female sexual organ is sufficient. Rape meaning is it available? Husband and wife, between husband and wife is available for the rape. Wife is that one, but the husband is one in the trying to do sex. That is a rape or not? That's the rape also. Between husband and wife, there's a relation, there's the sexual rape is available. A. Husband cannot rape wife. Traditionally, a husband cannot rape his wife, but he may be convicted as a party to the rape of his wife by someone else. But note, modern statutes in many states now allow forcible rape convictions for a husband, forcible rape of his wife. B. Against the woman's wills without consent. Intercourse is against the will of the victim is a several type of situation, all of which involve the rape of effective consent by the victim. Yeah, today is finished, chapter 1.
Kanino ako last meeting? Kanino ako last meeting?
Yeah, today is last.
Last meeting. 2 weeks vacation?
I don't know, 2 weeks or 1 month.
Oh, 1 month, okay.
Yeah.
Thank you, sir. Yes, vacation?
문제.